Ladies and gentlemen, today I am going to talk about disputes and alternative dispute resolution mechanisms being used in MES. First of all, what is a dispute? It's a situation when any claim raised by one party is not agreed to and rejected by the other party. So, why disputes arise? Causes leading to disputes in contracts are faulty contracts, faulty contract administration, default by the contractor, unreasonable attitude adopted by the contractors. Firstly, faulty contracts. The reasons are: number one, discrepancy or ambiguity in the same document of the tender contract or different documents forming part of the contract, contradictory and missing details in drawings. The other reasons are provisions in the contract not reflecting the actual site conditions, incorrect description of items, specifications, topographic mistakes, impractical provisions, period of completion. The local materials of specifications mentioned in CA are not available in the area. Material mentioned in the CA is banned by court order, like ban on mining of coarse aggregate, ban on mining of river sand, etc. Incorrect pricing of items or units, incorrect ground data. Coming to faulty contract administration, the causes are failure in handing over of clear and obstruction free site, or handing over of building by users, and also changes in siting. Next cause is delay in approval or rejection of sample or makes submitted by the contractor. Next, delay in decisions, clarifications, delay in finalization of drawings for execution of works, execution of changes without pricing, approval and placing of deviation orders, execution and completion of works of provisional schedules without finalization and approval of variation in quantities also. Next one is taking decisions without properly examining the contract conditions, recording incorrect measurements and or omitting to record certain measurements, failure in taking proper and timely action such as issue of notices, passing stages of work. Next is drastic variations in the works at execution stage based on the user's requirements and passing of defective work. Further, failure to maintain and make necessary endorsements in works diary and site order book and other important site documents. Failure in taking initial and final levels at the site before and during execution of earthwork. Decision not taken and recorded with respect to strata met with a site of work. Delay in making payment and making overpayments. Getting item of works executed outside the scope of work in contract, that too without finalization of star rates and even without obtaining basic details required for finalization of star rates, which are mainly consist of quotations, purchase vouchers, etc. and without contractor's consent, default by contractor, poor allocation and management of resources leading to delays and losses, non-appointment of well-qualified site engineers, representative, execution of defective and poor quality of work, failure to complete the work in time and then disputing levy of compensation, failure to complete the work leading to cancellation of contract, continuing default by contractor, furnishing of undertaking and then withdrawing the undertaking later on flimsy reasons grounds after department has taken a decision. Next one is employment of workmen of inferior skill. Again, procurement of material from unauthorized sources and by improper manner to save taxes, duties, etc. Subletting of work in violation of contract conditions. Non-deployment of utilization of mobilization for advance in the work and use it to elsewhere. Fourth reason for disputes is unreasonable attitude adopted by the contractor. In this comes raising of frivolous claims by the contractor, non-cooperative attitude by the contractor at the time of recording measurements and signing of star rates and deviation orders, deliberate avoidance by contractor in submission of purchase vouchers, test certificate and other documents sought by the department, contractor not attending to rectification despite number of reminders by the department, and lastly non-cooperative attitude at the time of finalization of final bill. I am going to talk now. Civil Procedure Code 1908 is applicable for the settlement of disputes outside the court. Under section 89, the 2002 amendment to the CPC 1908 is an effort at making litigation more effective and speedy. Where it appears that there exists elements of a settlement, court may by itself proactively refer a dispute to a alternative disputes resolution mechanism, to arbitration, conciliation, judicial settlement including settlement through lok adalat or mediation. Where a court refers a dispute for arbitration or conciliation, the provisions of Arbitration and Conciliation Act shall apply. To lok adalat, the provisions of the Legal Services Authority Act 1987 shall apply. For mediation, the court shall effect a compromise between the parties and shall follow such procedure as may be prescribed. Negotiation. Negotiation is directly between both the parties, between them. No mediation is required in the negotiation. Settlement is generally arrived at by discussing the disputes issues. So, no third party is required. Next is mediation. In the mediation, third party, a mediator is required. A mediator facilitates the resolution process, and a mediator does not impose a resolution also. So, he tries to address the problem by just facilitating the resolution process. Coming to conciliation, there is a third party, conciliator. It is a procedure like mediation only. The conciliator takes more interventionist role in bringing the parties together, suggesting possible solutions also, persuading parties to help achieve settlement. So, conciliation is a form of ADR, that is alternative dispute resolution mechanism for amicable settlement of disputes between parties. The features are: aim is to achieve an amicable settlement. Unlike litigation or arbitration, there is no judgment imposed, forced upon the parties, and any party is free to walk out of the process anytime if no amicable solution is expected. Next one is arbitration. Arbitration is a form of alternative disputes resolution between the parties, and the features are: dispute is resolved through adjudication as done in litigation. Adjudication is done by a third person, an arbitrator. An arbitrator, unlike a judge, is a private person appointed with parties' own choice. Judgment, that is award, given by arbitrator is final and binding on both the parties. Award is equivalent to a court decree and executed and implemented accordingly. So, advantages of arbitration are: in technical matters, appropriate special qualifications of the arbitrator enable for resolution are available. Speedier process than a court case. It will save costs. Unwanted publicity can also be avoided. Convenience of both the parties as to time and place is available. Simplicity of procedure if we resort to arbitration rather than court case. Arbitrator is appointed by consent of parties. Disadvantages of arbitration are: arbitrator may be incompetent or biased in some cases. He may suffer from infirmities with regard to procedure, evidence, etc. Thank you.